everyone, and welcome to another episode of At War, the podcast by the Conflict Law Center. Today, we are very, very happy to have with us Professor Hendrik Strydom, who is a professor of international law at the University of Johannesburg. Thank you so much for joining us today.
Thank you so much for having me.
So we're going to be talking about the proceedings between South Africa and Israel before the International Court of Justice. And I wanted to just start off by asking you how you think both sides did in the proceedings in terms of both the style and the substance in terms of their arguments and advocacy before the court.
Yeah, I think that both of the teams acted very professionally in the presentation of the case. Both teams were very well prepared, and they substantiated the arguments that they put forward, submitted to the court. Yeah, and I think from South Africa's point of view, it has at least made out a plausible case for Israel to answer. I think that should be clear. I do not think that South Africa will get all the interim measures that it is asking for, because some may be highly problematic. And I think on the other side, Israel has done well to put forward some critical issues which may raise some question marks about some of the allegations. One of them is whether there was indeed a dispute between the parties,
right?
Which, as you know, is required for the court to assume jurisdiction under the Genocide Convention. And then the crucial issue in the whole debate is the one about whether there's direct intent or genocidal intent, as it was frequently referred to in the proceedings. So, and that is a matter for the court now to decide. The facts are before the court. The application is before the court. The evidence is before the court. So it will be interesting to see how the court will negotiate with these crucial issues. And what the outcome will be. I think it is one of the most important cases in a long time before the ICJ. And we can see it from the international interest in the matter.
Yeah, I think it was very interesting that all sorts of people were then following the proceedings, and I don't think they'd ever followed ICJ proceedings before. So definitely in terms of all eyes being on the International Court of Justice right now. I think the conversation and the arguments made about a dispute were really interesting, because I think usually from what I've seen of the ICJ's case law is if you've got a dispute and if you've got a note verbal, the ICJ usually errs on the side of there being a dispute rather than not. But perhaps
Yes.
Israel was introducing a new criteria, which is the time to respond. And I wonder how the ICJ will handle that addition.
Yeah, you're perfectly correct on that point. The sort of time or the date on which it must determine whether there was a dispute is the date of the application.
Right.
In this regard, it's Israel's case that there was still an opportunity for bilateral negotiations between the parties, and they made a request for that. And after they've done so, the next day, South Africa submitted the application, the written application to court. And only a few days later did South Africa respond to that request, saying that it serves no purpose. So I think that may be an issue that places a question mark on whether the conditions for a dispute have been complied with. But once again, you're also right in saying that there is a tendency to err on the side of a dispute. And the other reason why you might be perfectly correct is because of the seriousness of the case. We sit here with a humanitarian crisis of epic proportions, of daily destruction, the disproportionate number of people killed. And I think everybody agrees that there is an urgency to the matter in trying to find a way in mitigating the consequences of Israel's military campaign. I think everybody is aware of that. So that might also, play a role for the court in deciding whether, in fact, there is a dispute before the court and it must be decided.
Yeah, and coming to the request for provisional orders that South Africa has given, the very controversial one, and perhaps the one that we have less precedent on, is that to halt military operations. So how likely do you think it is going to be that the ICJ will decide that Russia-Ukraine, where we did order that, was a very, very different situation, and we really don't want to wade into murky issues of the right of Israel to self-defense here, so let's sidestep that issue, really.
Yeah, that is one of the, I think that's the first order South Africa is seeking, is for the hostilities to come to an end. And I think South Africa is not going to be successful with that. The reason why I'm saying so is, as long as the hostilities are ongoing and the Hamas threat is still in place, Israel has a legitimate right to self-defense. If it stops the hostilities now, it has no defense against further attacks by Hamas. So even if the court decides to grant that order, I think the chances are very good that Israel will not comply with it.
Right.
For instance, if we compare that with the Ukraine-Russia case before the court, where a similar order was sought, and it was granted, and Russia just decided to ignore it. So the threat in this case, and we must remember that in the case of Ukraine versus Russia, Russia is the aggressor.
Yeah.
It is waging a war of aggression against Ukraine. Here, at least initially, Israel responded in self-defense against an attack. It was a victim of an attack. So it has a stronger leg to stand on. Should the court decide to grant that first interim order South Africa is requesting from the court.
Yeah, and I think in South Africa's proceedings, they tried to preempt that issue of self-defense by referring to the Ball Advisory Opinion, where the court, in very ambiguous language, did say you don't have the right to self-defense in territory that you occupy. And I think that will be one of the major things that we're looking at when it comes to the merit stage, even if they don't address that in the provisional order stage.
Yeah, I think I have to here refer back to the Israel wall case. And in that matter, that was an advisory opinion by the ICJ on whether the security wall Israel was building in parts of the occupied territories could be justified under Article 51, self-defense provision. And the court decided, I think, wrongly in that regard. It first of all says that the assault or the attack or the threat comes from inside Israel and not from outside. So, and that is totally wrong. There's a political and territorial distinction between Israel and the occupied territories. The fact that you occupy a piece of land doesn't mean that you have incorporated it or that you annexed it. So you need something more than that. And it is clear that we're talking about two different territories. So that reason that the court gave is false. And even in the Israel wall case, the language or the terminology used by the court supports what I just said. It referred to the right of self-determination by the Palestinians, of the application of international humanitarian law in the occupied territories. So that already gives us an indication that the court was talking about two different political components. So I think what happened afterwards with the other cases, the court will not sort of use that reasoning again. And the chances are good that the court will here decide that, okay, the threat comes from a different territorial element, and that it constitutes a threat which will be classified or could be classified as a threat under Article 51 of the UN Charter.
Yeah, I also want that clarified, but I think I argue on the opposite side of you that there is
Yeah.
the right to self-defense in occupied territory, and the law of occupation holds the field there. But it is going to be very interesting to see how the ICJ, both in the upcoming advisory opinion, but also in this contentious proceedings, how it decides these very, very great issues and very complicated issues.
Yeah.
And I wanted to come to the declaration by Germany that it would be submitting an intervention in these proceedings, and the ways in which Germany and also the UK are kind of constrained by something that they've already said in the Gambia versus Myanmar case, which is that they've already intervened in those. So the extent to which they're going to be bound by that, because from what I can tell, they've argued that a pattern of conduct can lead to an assumption of genocidal intent.
Sorry, I just missed the first part of your response there. What conduct?
A pattern of conduct.
Oh, the pattern of conduct. Yeah.
Yeah.
Yeah. Okay. As I understand Germany's point here, it's only intervening on the merits case, not on the interim measures.
Right.
So, and it has indicated that its sole purpose for intervening is to show that there is no genocidal intent on the part of Israel. So it will focus, I think, if I can take that statement seriously, they will focus on whether, from what has happened and from the factual situation, we can infer, or whether it's the only reasonable inference to say, yes, there was genocidal intent. And I think that will determine the nature and the scope of Germany's intervention on the merits.
Yeah, and when it comes to, we'll talk about the merits, but even about the provisional order, how likely do you think that any kind of provisional order, because I do expect that they'll give a protective one like they did in the Myanmar case, how likely do you think it is that it's going to be enforced or it's going to be ignored by Israel, and how can the international community ensure that it is enforced?
Yeah, the danger of Israel ignoring the court's order, or some of it at least, depends on the nature of the order. So if the court sort of overreaches and it provides an order that is perhaps too extreme and impacts too severely on the sovereignty of Israel and on what it needs to do now, it is very likely that Israel will ignore and not comply. So the court here must very carefully consider what orders may be acceptable by Israel, and then formulate it in such a way that there is a good chance, at least, that Israel will comply. So there's a very important responsibility that rests on the court here, not to overreach. Otherwise, there's no meaning in providing an order that from the beginning, the state who is to comply with it will ignore it, like Russia, who ignored the order to stop the hostilities against Ukraine. It's just one example. But the other part of your question is important, namely, what can the international community do if there is non-compliance by Israel with the court's interim orders? Okay, then, of course, the next avenue is for the case to be referred to the Security Council. But that is potentially also a dead end, because the danger is there that the United States will veto any decision that is taken by the Security Council, which is detrimental to Israel's position. So that is unfortunately the situation that we have to take into account, and which we can, and a possibility that we cannot ignore. The question then is whether outside the Security Council, states can put diplomatic pressure in some way or another on Israel to comply, or to comply at least to a certain extent with the orders. So there is also, I think, an obligation on the larger or broader international community to act upon the orders that the court may decide to give. in order to see that there is some compliance in some way to mitigate the threats that the civilian population is exposed to on a daily basis, and the destruction of civilian property and so on. So that would be very interesting to see how the court is going to deal with this very, very thorny matter, and what will be the outcome of the case.
Yeah, and fast forwarding to the merits of the case, how likely do you think that there will be a finding that Israel has violated its obligations under the Genocide Convention?
My assessment is there is a slight possibility. It's not more than 50. It's not more than 50%.
Right.
And that's my feeling. That's my feeling of how things stand at the moment. You see, what makes it all also difficult to be more accurate about a potential outcome is the fact that the court has evidence that we do not have as outsiders. There is already evidence before the court, apart from what was presented by the parties, orally or written in a written fashion. So, and there is now also further opportunity for the court to obtain more evidence. It can, at this point of the proceedings, still contact the parties and ask for more explanation on this and that. Or it can also, from other sources, obtain information. So that makes it difficult, but as things stand now, I cannot say that there's a bigger chance than 50% of the court making that ruling.
Yeah, and I think it's such a difficult case to prove because genocide is the hardest international crime of all of them.
It is. I fully agree with you on that. It is a very difficult thing to prove, direct intent, because that is what is required. And the complexity of this conflict makes it even more difficult.
Yeah,
it's
and
different.
Yeah.
For instance, it is different if you can, by way of comparison, just mention one historical example: the Srebrenica genocide. And the Rwanda situation. So there are more sort of various aspects which may impact on whether there is direct intent or not. So that is why I made the estimate as I've done.
Yeah, and I think I side with you in erring on the side of caution as well, because when it comes to Myanmar, we had UN independent fact-finding mission, the report that the Gambia relied so heavily in its application, and we don't have anything of that sort here. But perhaps by the merit stage, because it's likely that this will go on for years and years, we might have something by then.
I perhaps I could just mention that in closing. What is also before the court now are I think about 15 reports by UN bodies and special rapporteurs of past conflicts and what happened. So that evidence definitely, or the pattern that those reports exposed, are well aligned with what is happening in this conflict. So, and I think those reports will certainly be considered by the court on the merits phase, because they all have the same pattern. And then it is for the court to decide how it's going to interpret that in order to come to a conclusion whether there is direct intent or not.
Yeah, I agree with you, and perhaps we can have this conversation again once the order comes out. But thank you so much for taking out the time to talk to us.
Thank you, and I wish you all the best.
Yeah, thank you so much, and thank you so much for watching at home.